Yeah, she'll go ahead and address that. Just to make sure that your cell phones are put away out of sight, please. Yeah. And that we do have them on silent or quiet mode. Yeah. Thank you. Yeah.
Welcome back. Let the record reflect that we have counsel as well as the parties. Just one housekeeping matter, because we are concluding at 4 p.m., the afternoon break will be at 2:45 to 3 instead of 3 to 3:15. Are we ready for our jurors?
Not just yet.
Can we ask you something?
Go ahead, sir.
On 9/8, Judge Blanchard said no duplicates in a minute entry. Mm-hmm. And on 9/28, Judge Blanchard said we're allowed to challenge the validity of the subpoenas, foundational. 9/31, I think it was the minute entry. And you're not letting us challenge that.
That's motion in limine number 4.
Granted, denied his.
Denied him, but granted it to us. We have the right to have him authenticate his subpoenas, which he didn't start with subpoenas. He started right into bank records.
He started in with an affidavit. That's not authentication of the subpoena.
Judge Blanchard told him he had to surpass the authentication hump, and he's not doing that. And that was his words.
Thank you. Your objection is noted. Counsel, wish to respond?
I don't know exactly how to respond to that, Your Honor. I mean, it's kind of weird to authenticate a subpoena. You know, if we're talking about, I don't know how the bank would authenticate a subpoena. It's a subpoena that came from our office. They could, and I think that the subpoena is not necessary to authenticate the records. Under the records that came in are allowed to come in under the evidentiary rule that I cited to, and as self-authenticating. So I don't need to authenticate the subpoena separately, and the bank probably couldn't authenticate or lay foundation for the subpoena. They would only indicate whether they received it or not.
And I believe that's what you were trying to establish in this first witness, which you made it pretty clear to the jury whether it was, I'm sorry, go ahead.
I hope so, but there's no document speaks for itself anymore from what we understand.
So what you did was challenge that particular witness with regard to his records, where they came from. And so what your argument would be, because you made that very clear to the jury on that first witness, what you were alluding to about the subpoenas. So your argument would be to the jurors exactly what you're telling me about those documents. Go ahead, sir.
I understand.
Mr. Easton is saying that the subpoena isn't basically an
It's
important thing.
how the records was obtained, and it was obtained unlawfully. And we shouldn't be allowed to have to fight each and every document that's submitted that we know is going to be an issue with, that has been changed.
The subpoenas were not.
When he didn't follow the process, there's proof in here that I do believe we submitted that will challenge the validity of this process of how he obtained these records. And I don't think serving it by email is going to be a valid legal means. And then,
So go ahead.
then he sent an email to U.S. Bank, and this is the issue with U.S. Bank, he sent an email to them, and then he said, I'm following up on that was served. Well, we have the evidence that, I don't know if it's in there still or not, where we talked to the bank manager, he never received a subpoena, but yet because he talked to an admin at U.S. Bank, they said give it to him, and then he realized a year later, there's no affidavit. And then we talked to Shannon Miltner, who is the custodian of records and paralegal in Minnesota. She said she would only have given an affidavit if she had had a subpoena.
Well,
There is an issue with this, and then to have him have
And you most certainly can argue exactly those words that you just told me in front of the jury. Exactly what you just said is exactly what you'll be telling the jury, because you established that through that first witness.
Still, the documents
So
are.
your argument is, look at all of his exhibits, but it didn't follow the protocol that you've argued. That's your whole argument, and that's what you want the jury to hear. So you challenge that first witness about those records.
But will they exclude them? It's still going to be a
No,
lot.
it's not whether they'll be excluded, it's the weight that they'll give to them. Do you see what I'm saying? So they can review those documents, and you can say you can look at them all you want. But I established through this witness X, Y, and Z. And so they have to determine whether they believe that argument or not.
Well, he kept challenging the foundation of everything we did, and he took 2 hours to try to get the man to clearly understand that
so-
the subpoena history didn't show it.
The documents that have been admitted, those are documents that they'll look at. But your argument, the first argument that you're going to make to the jury and your closing statements is, you saw the testimony of that first witness, and I was able to establish X, Y, and Z through that. So that's your argument to the jurors. Do you see what I'm saying?
Mm-hmm.
So I know what you're saying.
In the situation with U.S. Bank, Your Honor, Ms. Welton was the one we talked to. She was still upset a year and a half later that he went over her head to an admin. What he did is he called up like he had already submitted a subpoena, which
Served.
the bank manager said, no, there was none there. And then he told her he would email the subpoena that he had, and because he went over her head to an admin, the admin said, go ahead and send it.
Back up.
So you're obviously what I hear you telling me is that he obtained these records improperly.
Yes.
Is what you're arguing. Now your argument would be, I established that through the first witness because that's what you were trying to establish through him, right?
Except those were Compass. This
And then
is
you're
not
also
Compass.
going to make an argument, which I heard you starting to do, but the argument time isn't with the witness, it's going to be to the jurors. That you're saying you established through the second witness that was on the stand that although these were released on this particular date, there's been several years that have gone by, is it possible they could be altered? That's another argument that you're making to the jury. So they're hearing what you're saying. But as far as the custodian of records, they're just saying, they're laying the foundation that they came from this place.
But they're stating more than that.
Well, he was unable to state more than that, the first witness.
They're stating that it's identical, such as Banner Health. There's identical this, and it's like there's
No.
issues.
But your argument to her was, once they're released, could they have been altered? And she said, I'd have no way of knowing. So you're establishing your points through those witnesses. So I hear what you're telling me. But as far as the custodian of records, they're just going to testify they came from their place of business. That's it.
They're stating they're
So-
identical, but they're not.
They believe that those came from their place. Now, can she testify, the lady from Banner, can she test, Ms. Ficus, could she testify that have those been altered since they were released? She said no. That's what you've tried to establish. So you're making your points. I understand that you disagree with those records. The jury understands that you disagree with those records. Your argument to them is why you disagree. Does that make sense to you?
Yes.
So you have established that. So as far as arguing those, you have argued those points about the subpoenas. Go ahead.
I guess my opinion is as well, that I don't think that something known and forged should be entered into evidence to be considered, considering that it could go either way, especially when you can prove the validity that isn't true. But yet, we were prohibited from bringing in, because Judge Blanchard's words were, any duplicate records, the court will remove and take the first one, which means plaintiffs. That's an open door policy to guess what? To do a little creativeness, and
Because
that's
we
where
don't
we
have the
are.
duplicates, because you said no duplicates, otherwise we would have had our records.
Whether we're not being difficult, we're just going to explain to you.
No, understood. But if you have those records at home, let's say you have those records at home that we were arguing about earlier, right? The packet, and you said you believe these might be fraudulent or forged. And I said, well, where are yours to compare it? You're like, I don't have them.
Not anymore.
Well, no, we have them, but we
Have them.
Yeah.
Then bring them with you. And then when you come here at 9:15 or whatever, take your packet and look at that packet and see if they match. And if they don't match, have yours marked as an exhibit. Does that make sense?
Pretty much every one of those on that board that he has our name to, even the credit card ones, they've
Irrelevant.
all been
So,
closed.
so when Judge Blanchard ruled you can't have duplicates, it would be two of the same subpoenas.
and we argued that.
And so that makes sense, because why would they look at the same thing twice?
It was two of the bank records, because there's a ton of bank records, as you can see.
But today you presented two documents that looked similar, right? He had a subpoena and you had a subpoena, but it said original at the top. Now those, they're not in duplicate because one was a bit different. Do you
One's a
see?
copy of the
So that's why I
original.
allowed you to talk about those. But if you bring in your packet, you're welcome to bring in any documents you want and compare them to any of the exhibits that you want. And if you see that there's something different, that's not duplicate.
Okay, well, that's what we told Blanchard, that's what we told Judge Cohen, we told Lisa Flores, Judge Flores, and even Sally Duncan, and they all said that's just, it's duplicate.
They wouldn't address it.
The court don't want to address stuff like that. I get that, but the point is when it's a clear difference and we know our bank records.
Well, you're welcome to bring any documents that you have that you believe that they've been disclosed. Now, both sides have had to see these things. They had to be disclosed during the course of this trial. It can't just be something new that you pulled out of the closet.
Right.
It had to be something
I appreciate that too, because see, you're the first one that's going to allow that, because 8 years have been trying to get that comparison.
So bring it and then show me what's different. So if you show me a disclosure statement says this was given to you, and you're saying, okay, said this was given to me, this is what I got, and it's different, I'll look at it because it's not duplicate. Does that make sense?
Yes, it makes sense. Thank you.
Yes, ma'am.
I had already know because I forget easy sometimes. This, Mr. Easton, even in, what was it, a motion in limine, I forget which one it was, but he was telling the judge that we should not be allowed to go outside relevant time when we were going to subpoena the Johansson's records.
Yep. In fact, it
But
was,
now he's telling us just opposite. It's okay for him to be outside of all this relevant time, which is after this case was filed and after, or, you know, just not relevant time. But yet we have to adhere to that.
All right, so let's talk about,
and
so I
he
think you're
wouldn't.
talking about the medical records for Mr. Johansson.
And the
It's
bank
after the time that
in some, in part.
after the date the complaint was filed. If he had a prior, the doctor reviewed records, I'm understanding, the doctor reviewed records before his records that were before the filing of the complaint as well as after the filing of the complaint to see if his illness progressed. Is that?
Actually, the records reflect a day and night difference, because as soon as they filed this lawsuit, everything changed because there was nothing mentioned about Alzheimer's, Lewy body, or anything.
Let me ask that question. So the documents that this doctor reviewed, did they reflect his condition before the complaint was filed?
Yes, Your Honor. Back to 2014, 2015.
No, Your Honor. They only alluded to something that might be Parkinson's or Alzheimer's in November. There was never an official diagnosis, because most of Mr. Nicky O'Coiney's a doctor that Gary had. Most of them says no official diagnosis on every document.
A Lewy body.
Okay, and the jurors are going to see those documents, and that's your argument to them, exactly what you're telling me. So everything that you're telling me, you're able to tell the jurors this in your closing statements.
You do know this is going to take longer than 8 days then?
Well, no, it will not take longer than 8 days because that's all the time that we
As you
have.
can see how many documents he's putting through.
You're going to have to figure out how to narrow it down, your arguments, because it will not be extended.
He's going to, well, when he hits his 17 hours,
It's
then
only
I guess
making
we'll
him
get
Exactly, when everybody hits their
Jury
17 hours, it's over,
minus my 15 minutes.
minus your 15 minutes.
See,
But
the
I was
relevant
right,
time,
Your
Your Honor,
I was
is
right.
2015 to 2017. That's the time that we interacted with them before this lawsuit was filed. He should not be allowed to go past 2015
But
like he did
it actually-
2013 on our bank
It
records.
actually works in our favor because of the sudden shift in the medical records. It seriously did shift.
This
And
is
that-
a
and
thing
that's your
that are okay
argument.
for him to do, but not the same thing
Well-
for us.
And the other issue was
Go ahead.
Bank of America records he obtained during discovery time and didn't disclose to us late. Okay, he held them for 4 years, 5 months. And in those Bank of America records, we did subpoena them. Well, Judge Blanchard ruled against us because he said it was outside the time frame, but the Bank of America records in that subpoena covered the time frame as well. But he late disclosed them, and now I don't see them in there. It's another issue, but yet they were in disclosure.
Disclosure number.
And again,
Now, let's talk about
15.
disclosure. If he discloses things, he doesn't have to use them all at trial.
No.
right, but we can, and they were in there.
If they were disclosed to you, then you have to bring your copy and have them marked. So if you can't just rely on what he's bringing. So if he disclosed them to you, he could disclose all kinds of things to you and submit one.
May I explain
Yes, sir.
something? When this took place back in August last year, he gives this big, long laundry list of things he's going to submit. So we're told not to put duplicates in because they'll be taken out. Okay? We don't. Then what actually gets submitted when he brings in is not in there. It's all changed. They renumber ours and rename our exhibits, and we have a hard
did
time
that twice.
collecting. We actually have to go down to the courthouse and go through each and every exhibit to find out what the name is and the new number of it is. And in fact, I think I have the copy of it here where it was, just to get that. Then it was missing, and it's too late because they said this only what's going to be used at trial is what was submitted now. You're letting us know something different that was said different before. So when things got shifted and things were removed, and okay, we could have had them in there, even though they may have been duplicate, if he was going to remove them. is what I'm saying. So there is the 14th disclosure statement where it covers 483 pages that he obtained through Adult Protective Services here, where they did request bank records from the Johansons through Bank of America, which is what he had Judge Cohen or whoever exclude them out. It's the same records he got, and then he disclosed to us. But because he was putting those in at the time, and then they were removed, okay, by the time this was all said and done,
Those records are not in the
we
exhibits at
did
all
submit
for Adult
the
Protective
full
Services.
14th disclosure, the 483 pages, because those bank records, and Ms. Dockstetter was the investigating agent on the
Adult Protective Services.
Adult Protective Service investigation. She made handwritten notes on there. It's important, okay? And he didn't disclose them timely. We mentioned this to Judge Blatcher. He said, well, he'd deal with this at court. Well, it's a little bit late when we're here. And then he says, you can't put anything in after the exhibits are submitted. It's only what's going to be submitted at trial.
It makes it
But if
very
you're going to let us
confusing.
bring those in, we'd be more than happy to bring them in.
Bring in, we'll see what you want to have admitted. But right now, I'm going to be frank with y'all, jurors have no idea what's going on.
I understand. They're sitting there watching people flip through documents
Yes.
and don't even know what the documents are about.
And time's ticking.
If I'm correct, the rules of evidence, I think it's 702, even states that you have to bring originals to trial.
Different
Am I
question,
correct
isn't
on
it?
that?
Is there a question about authenticity of a document that's been
Yes.
introduced?
Of-
He's laying the authentication through his witnesses of the documents.
But see, that's,
You're welcome to make your objections. We can't just talk in general statements. We got to bring those jurors in, okay?
thank you.
All right, thank you.
Thank you for
You're-
letting us ask you these questions.
Absolutely, you bet. You're welcome to bring your witness back.
Thank you, Your Honor.
You bet.
I hope I never have to go through this again.
You shouldn't have been in the first place.
It's an experience.
It's
Actually,
okay if you're on the other side, but when you're on that side, it's not an experience.
it's an adventure.
Okay.
Welcome back, Ms. Martinez. Please remember you are still under oath. Thank you.
Is this the same exhibit?
Nobody touch anything on your desk. It's the same exhibit.
All rise.
It looks like it.
Was that 15?
Welcome back, everybody. Please be seated. Let the record reflect the presence of our jurors, witness Ms. Martinez, counsel, as well as the parties. All right. For the lunch break, we left off with counsel participating in direct examination of Ms. Martinez. We will pick that up from here. Also, because we've all agreed to end our workday today at 4 o'clock, our break will be earlier. The afternoon break will be at 2:45 to 3 p.m. Thank you. Go ahead, counsel.
Thank you, Your Honor.
You're welcome.
Ms. Martinez, we were reviewing some bank records that were produced by U.S. Bank, and I believe you were at Exhibit 16 or 17. Which one do you have there in front of you?
16.
Had you finished your review of that before we left for the break?
Yes.
As you look at Exhibit 16, were you able to confirm that these are true and accurate copies of the documents that were produced from U.S. Bank pursuant to the subpoena received from my office?
Yes, that's correct.
Thank you very much. And then, do you have Exhibit 17?
Yep.
From 10 looking?
Yep.
Thank you. May I approach?
Yes, sir.
I want you to look at Exhibit 17, please. Having reviewed Exhibit 17, can you confirm that these are true and accurate copies of the documents that were produced by U.S. Bank in response to a subpoena received by Mr. and Mrs. Johansson?
Yes, that's correct.
And are these U.S. Bank records the name on the account of Nick Casavelli doing business as Aspire LLC?
Yes.
And is it an account ending in 2077?
Yes.
And back to Exhibit 16, are these bank records titled for Nicholas Casavelli and Nicolina Castelli for an account ending in 6370?
Yes.
Thank you so much. Showing you Exhibit 18.
Yes, sir.
I'm showing you what's marked as exhibit number 18. Will you take a look at those, please? Thank you. Having reviewed those, Ms. Martinez, can you confirm that these are true and correct copies that were produced by U.S. Bank in response to a subpoena received from Mr. and Mrs. Johansson?
Yes.
Thank you. Your Honor, I move for the admission of exhibits 15, 16, 17, and 18. And I believe there's one more exhibit up there, maybe exhibit 100?
99.
99, and 99 as well.
Defense, any objection?
Foundation.
They're self-authenticating, Your Honor.
Over your objection, 15, 16, 17, 18, and 99 are admitted.
I'm done with questioning, Your Honor.
Cross-examination?
Ms. Martinez?
Yes.
These exhibits, how do you know who they belong to?
They have the names on there. Do you mean like the accounts? What the accounts are?
Well, how do you know they belong, say, to me?
So the statements do have the names of each account and the owners.
And how would you say they were produced?
They generate on a monthly basis for each account that's open with the bank.
How would Mr. Easton have obtained a copy of that?
Through a subpoena.
Did you see the subpoena?
Yes,
Was it served at a local branch?
correct.
Is it on file with U.S. Bank?
Yes.
And yet, when requested, it wasn't produced by us through a subpoena.
Objection, Foundation.
Overruled. I'll allow it. She can answer.
What do you mean by you?
We requested a copy of that subpoena that Mr. Easton allegedly served for those records. U.S. Bank could not and did not produce it.
Objection, Your Honor. He's testifying. He's not asking a question.
Well, did they produce a subpoena that we requested?
Sustain.
I'm not sure if they produced it.
So how do you know that those expenditures are accurate in those accounts?
So like I stated before, normally when an account is open, they produces monthly statements, and it's all the transactions that have, been through the account for that month.
When were those produced?
So each of them have a specific date on them.
Correct. What year, just roughly?
So if I look, it looks like 2017.
On which exhibit number, please?
So for the account ending in 6370,
What exhibit number on the green tag?
this one is 16.
Thank you.
And then this other account, the same year, 2017, for account ending in 9483, exhibit 15. And then we have an account ending in 2077, 2017, exhibit 17.
Can you explain why U.S. Bank would issue an affidavit almost 2 years after an alleged production?
Issue an affidavit. Can you clarify the question,
I
please?
believe it's one of the first documents he used up there, claiming that there was an affidavit of,
The affidavit of custodial records?
yes.
I think that's just for Shannon Miltner to state that she's a legal records coordinator for U.S. Bank.
Can you state why it would be issued almost 2 years after an alleged production?
I cannot.
Is that normal practice when you produce a subpoena production, not to give an affidavit at the time of production?
I am not 100% sure if she issued it when the subpoena was.
The date says on there when they requested it.
Let her finish the answer. I couldn't hear what you said, ma'am. Could you repeat that?
Yes, I said I'm not 100% sure if she issued one when she first got the subpoena.
That would then bring into question why the affidavit has a date 2 years after. Would that be certifying that the documents weren't certified for the first 2 years after receiving them?
No. To my understanding, the affidavit is to state that she is a legal records coordinator for U.S. Bank.
Does not the affidavit support the authenticity of the supposed documents issued?
Yes, but I'm not 100% sure again if she's provided one when it was first submitted, like the subpoena.
Okay, if she didn't provide one and the subpoena was first produced, the documents, then there was no certification of those documents for 2 years until 2019 when the affidavit was issued, correct?
Well, all I could state was that the affidavit was issued the 2019, and the subpoena was received 2017, but that's all I could pretty much state that she did for that.
You just stated, for the record, if I understand, that an affidavit is to certify the production of the records, correct?
No, all I stated was that what she did was provide the affidavit on 2019 for the subpoena that was received 2017.
So she's stating that there was just a subpoena received in 2017, but she didn't authenticate any documents.
I'm not 100% sure if she did or not for 2017, because what I have in front of me is 2019 that she provided an affidavit. So I'm not sure for 2017. That's all.
Is there a standard across the banks of how they're to process subpoenas?
Yes. So normally when we process subpoenas and we receive it at a local branch, we take in the subpoena and send it to our legal records department. So they are the ones that review and supply the documents requested.
And when the documents are requested, what is usually returned with the documents?
Not 100% sure because I'm not in that department. So that department specifically works on delivering the requested documents from
So
the
you
subpoena.
can't authenticate these documents 100% because you don't work in that department that produces the documents. Is that correct?
If the legal department can't find the documents, I am able to pull from our internal systems. So like all of these documents I work with for U.S. Bank. So I've been producing this. So I supply it to them and they are the ones that send it out to whoever is requested the documents through the subpoena.
And the affidavit is produced at the same time, correct?
Again, I'm not 100% sure if it is or not.
So what do you do at
So
U.S. Bank?
What I do is I support, Arizona, Nevada as a market operations analyst. I am able to pull internal documents, support branches. So I work with our internal systems, and I'm able to produce these type of documents to supply, let's say, to the legal department, any other internal department that requests it from us in the branches. We are able to provide it to them.
So you would
But we
produce.
don't answer subpoenas. We take in subpoenas and we send it out to our legal department.
That was my next question. So you don't produce documents for a subpoena, then how can you validate these documents are from a subpoena?
Well, we do provide it to our legal department who answers the subpoenas, but we take in the subpoenas, provide documents if needed, and help in that way. And then they are the ones to respond and send anything else that is requested through the subpoena.
I'm not clear on this because you're saying that you don't do the subpoena production, but yet you provide documents for the production. In part, in whole, which?
Yes, that's correct. So we supply documents that they are not able to pull from any internal systems. We are able to pull it for them and send it out to that department. And that department is in charge of answering and collecting all the files to send out.
Then what is the affidavit for?
The affidavit is to, again, state that Shannon is, legal records coordinator for U.S. Bank. So she's the one that provided this in 2019
But
to
you just,
respond to the subpoena.
did you not state that you supply them documents for this?
Not this specific one, but I do in what I do in U.S. Bank, I do aid in, producing these types of documents, but not this specific.
So you don't really
situation.
understand the entire subpoena process through your own bank, then, do you? Or you're not there from step one to step final, are you?
Objection, compound.
Sustained.
Are you aware of the full subpoena process from the time of service of the subpoena to production?
I would say no, since we don't answer the subpoenas, but we do take in. We are there to take in the subpoenas, send it to the correct department, and then, again, help if needed. If they request additional documentation, we are able to pull from internal systems.
If I'm correct me if I'm wrong, but you're basically stating that you're a department or a person that forwards subpoenas to the legal department.
Yes, we do forward it to the legal department.
So you really wouldn't have any knowledge firsthand as to if these documents were actually produced from the subpoena department?
Like these specific documents?
Any documents for that matter?
Yes, like I said, I do pull, so I've seen, these types of document statements, everything that's included in here, I am able to verify since I do work with these types of documents on a day-to-day basis. But again, we just don't answer the subpoenas. We do take in the subpoenas and don't.
I'm asking specific documents, not types of documents. I understand that banks deal with certain types of documents, and that's it. There's a wide range of those types. I'm saying, do you have personal knowledge of these production of documents?
Of these specific documents?
Yes.
If your question is of bank statements, then yes, but these specific documents, no.
And you cannot explain the 2-year difference on an affidavit that was produced after an alleged production of documents.
Yes, that's correct.
And then there's no way of certifying that the documents that was allegedly produced in 2017 are true and correct, is there?
By looking at them and knowing our internal documents, I say yes.
If you was to look through those documents, then can you tell me that if I made a purchase at, I don't know, IKEA, that I actually made that purchase?
Based off how it was purchased, we would say it was purchased through your debit card or whatever it may be.
I didn't ask how. I said, can you state unequivocally that I made that purchase?
I mean, if you're saying if you personally went to the store and did it, we can't verify it. All we could verify is that it came through your account and then what specific type of way it came out of the account.
Have you matched those records before you to the records at U.S. Bank to make sure that they're an exact copy of what you have on record?
Through my knowledge, yes.
When?
Just by looking at them They look exactly like the statements that I've worked with for the bank for the past 8 years.
When is the first time you've seen these documents before you today?
So this one I've seen through email, and then these specific statements, it was today.
So how could you compare documents that are sitting before you today prior to what's on U.S. Bank now?
They look exactly the same as, again, like I stated, I've been working with statements and our internal tickets for the past 8 years, and they have not changed.
Ms. Martinez, do you have a photographic memory?
No, but from collecting memory,
I
yes,
ask you
I can compare
again.
them to,
I ask you again. You're comparing documents. You're comparing kind and kind, not exact and exact. Is that what you're saying?
no.
So you're saying that you can compare this exact document with what you know is with U.S. Bank?
From what I know, if I had my work computer with me, we could probably compare them. But from memory, from how I've been working with the bank, yes, they look exactly the same.
Okay, so you can go through each one of those and tell me that I made that purchase and which purchase it is.
We could say that it came out of your account.
I didn't ask that
Through
question.
this purchase and the type of way it came out of the account.
I asked if you could identify each purchase that I supposedly made, is what I'm asking you, from memory, from seeing them today, from what you know in the bank records. Because you're testifying here today that these are true and accurate copies, as Mr. Easton asked you.
Yes, that's correct.
How do you know they're true and accurate copies?
Again, because I've worked with these statements before, they look exactly
These
the same.
exact statements, ma'am?
No, the same type of statements that
Thank
our
you,
bank
thank you,
produces.
Thank you. So you're saying that they resemble all statements that U.S. Bank produces?
Yes, that's correct.
Content's different, correct?
No.
No.
Oh, well, yeah.
From different.
From different customers, different transactions. Yes, that varies for, of course, account numbers, everything else varies. The actual information varies, but how the statements look and how the information is placed on here is the same.
Do these documents get produced locally?
No. If a customer requests, then yes. If we print them out for a customer, then we are able to print statements out at the branches locally.
Is it standard practice to have markouts on documents like that, cross-outs of numbers and names and things of that?
I don't get your question there.
I think it was Exhibit 17, first page has strikeouts through it and lines and corrections.
It doesn't, it just blocks out the account number. But other than that,
May I see number 17?
yes.
Ouch.
This one?
Yes. Turn this on, please. You can see this document, correct?
Yes.
Is this normal to have markouts for supposedly a counter withdrawal for how it was withdrawn?
The strikeouts might have been to just block out the information on there, but do you mean like the bottom?
Well,
Or where?
you can see here below the redacted mark, there's a 43, I don't know if it's 4307 or what, but it's got a strike through. Why would that be on there?
It looks like they might have been made a correction, so they strike it out to process it again, which is on the other side, on the left.
And who would have wrote this on here?
Could have been the customer, banker. If they were trying to buy a money order or cashier's check, they typically write, on the back.
And the customer normally has their hands on a counter withdrawal ticket?
Yes, they normally sign the top, which is a name, amount, and then of course signature date. So they would handle a counter withdrawal.
This many mistakes on her, why wouldn't someone just issue a new one? Why would the bank accept someone with so many mistakes?
I'm not sure.
Overruled out loud, she can answer. Go ahead.
Not sure why, the banker processed it this way, but they do, I've seen it sometimes where they would scratch it out and process it on the other side. You could see that it was validated on the other side.
Validated. How do you mean validated?
So our scanners, normally you would put it in validated so you could see where it's scratched out on the other side. They validated it again with another to process the transaction again.
So this, explain how is this transaction processed twice then? And with all the pertinent information struck out, why would it be?
So it wasn't processed twice. If there was a mistake through the validation, through the transaction, they would void the transaction and then scratch it out or put a line through it and then validate it on the other side.
Then where's the actual validated transaction if it's been
It's on the left where it says.
over here? And half of it's redacted, how do we know?
Again, I think it's to block out the account number so you could just see the last four of the account number.
Do you know who that is? The name of that person on the bottom?
No,
Do you know if he's an attorney or just a customer or anyone?
no.
So for understanding, and it'll be my last questions for you, that, well, second to last question then. Do you know which branch the alleged subpoena was served at?
By looking at the documents, probably. No, the response here doesn't say.
Have you seen any documents that suggest where those documents originated from, or even if a subpoena?
Can you repeat the question?
Did those documents originate from a subpoena?
Do you mean all the exhibits
Yes.
were a response to the subpoena?
Is there any documentation before you that supports those documents being produced from a subpoena?
Yes, so the response, it says, on behalf to response to a subpoena we received on November 2017.
What date is on that?
Which exhibit are you referencing, please?
Exhibit 99,
Thank you.
and this is a response dated March 12, 2019.
Again, that's not the relevant time of the alleged production, is it?
I'm not 100% sure.
It said 2019, you stated.
Yes, that's what the response says, the letter as a response.
Yet you're testifying that these documents were produced in 2017. Is that correct?
No, I'm testifying that the response that Shannon gave on Exhibit 99 is from March 12, 2019.
Yet you're saying the production dates are on the documents of 2017. And you're here to validate the authenticity of them, are you correct?
Well, the documents that were produced for the account was 2017. So for Exhibit 17, 16, and 15, they were all bank statements produced 2017 for those specific accounts.
Okay, please explain for the ladies and gentlemen of the jury of how that you can contend that the documents from 2017 and an affidavit from 2019 connect, that is the actual and true production of a subpoena.
So I am stating that Exhibit 15, 16, 17 were all produced in 2017 based off for the accounts, the prospective accounts that each of them are titled or have on the statements. They were produced in that specific year for those specific months for that account statement.
But where is the subpoena to produce the production?
It is Exhibit 99 would be the subpoena. And that is attached with the response from Shannon Miltner to the subpoena.
So you're saying that an email subpoena is acceptable for U.S. Bank, that you can email your subpoena and you will give production from it?
No. I'm just stating that Exhibit 99 was the response from Shannon.
What
the
date?
subpoena that we received.
What date's on Exhibit 99, please?
Her response is March 12, 2019.
Again, that's 2 years afterwards. Can you explain why there's no subpoena at the time of 2017, the alleged production of documents?
The subpoena is attached to this exhibit.
It's the date of the exhibit you just stated is 2019, correct?
I said her response is 2019, yes.
That's what you stated. Her response with the affidavit, correct? 2019. But there's nothing at 2017, correct? For an affidavit or subpoena?
Do you mean a response from her? No.
No. There's no subpoena dated 2017 at the time of 2017 production of documents, which would be normal. Would it not for a U.S. Bank to send a copy of the subpoena with the production?
The subpoena is attached to this as well,
To what's this?
to the affidavit and the response.
Which is dated.
2019? That's the response.
I have no more questions.
Redirect?
Please, Your Honor. May I obtain from you the Exhibit 99, please? Thank you. Can we throw that up there? I'm showing you what's marked as Exhibit 99, which has been admitted into evidence. Can you please read to us the cover letter there from Shannon Miltner, beginning with Dear Requester?
Yes, dear requester, I am writing to you on behalf of U.S. Bank National Association in response to a subpoena we received on November 9th, 2017. Enclosed, you will find a notarized affidavit of custodian records regarding the bank's document production dated November 14, 2017, pertaining to the above case. If you need further assistance or have any questions, please feel free to call me.
I'm going to pull that down a little bit, and the date of this letter is?
March 12, 2019.
Thank you. So clearly she's stating that this is in response to a subpoena received on November 9th, 2017. Is that correct?
Yes.
And then on page 2, Ms. Miltner goes on and provides an affidavit of custodian of records. Can you please read for us, beginning with I, Shannon Miltner, up here?
I, Shannon Miltner, being duly sworn, dispose and state as follows. That she is an authorized custodian of records employed as a legal records coordinator for U.S. Bank National Association and its affiliated and predecessor corporations, that she has authority to obtain records and data maintained by U.S. Bank in its files and or data processing systems of U.S. Bank National Association, and as such have been designated as the custodian of records for the purpose of responding to the attached subpoena.
Please go on.
The 19 pages and 3 discs containing 588 pages of documents delivered with my letter dated November 14, 2017, in response to the subpoena represent true and correct copies of documents which are in our files. These records were prepared in the ordinary course of business at or near the time of the act, condition, or event.
And again, the third
The
paragraph.
19 pages and 3 discs containing 588 pages of documents delivered with my letter dated November 14, 2017, represent a complete response to the subpoena as of this date. A full and complete search has been performed to locate all documents which fall within the purview of the subpoena, and she is not aware of the existence of any further documents which would fall within the boundaries of the subpoena.
Thank you. So in the paragraph you just read, that the response being provided herein with this certificate is a complete response to the subpoena as of this date. Is that correct?
That's correct.
And if she had previously produced the documents before, let me do this hypothetically. If she had produced the documents before and accidentally omitted providing the certificate, would she then, in order to produce this certificate, go back and ensure that what she did before was true, correct, and accurate?
Yes.
And would you have done the same thing in your position as custodian?
That's correct.
Thank you. From your review and from your and looking at the documents today, were the procedures that are established by U.S. Bank for production of documents followed?
Yes.
And based on your review of the production, based on your review today of the documents that were provided by U.S. Bank, do we have true and accurate copies of its banking records?
Yes.
Thank you. No further questions, Your Honor.
May this witness be excused?
Subject to recall as necessary.
You bet. Thank you. Thank you so much for your time today. May I have those exhibits?
Yes, of course.
Thank you. You may call your next witness.
Your Honor, it would be Dr. Pamela Wilson, who will be appearing virtually. And may I call my office to tell her to link in?
Yes, please. Thank you.
She's actually already in the virtual lobby.
She's already there.
Yes.
Fantastic. Okay. I have an exhibit here that I think was admitted. Give that to you, sir.
Mr. Easton, we have let her into the virtual lobby. She'll just need to activate her camera and her mic.
Okay.
You want to just let her know in that little. Just speaking to the microphone.
Speaking to the microphone. Dr. Wilson, if you're there, we see that you're admitted to the virtual meeting here. Could you go ahead and activate your mic and your camera so we can see and hear you?
I did.
In the process. There you go.
Good afternoon, Dr. Wilson.
Good afternoon.
The court, I believe, wants to probably swear you in at this point as you're about to give testimony in this case.
Dr. Wilson, this is Commissioner Molyneux. Can you hear me?
Yes, I can.
Thank you. Would you please raise your right hand to be sworn? You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And although you're appearing by Teams today, please do not reference any documents unless you let your attorney, the attorney, know that you need to refresh your recollection, okay?
All right.
Thank you.
Dr. Wilson, could you please state your name and specifically with your last name, spell that for the court?
Sure. My name is Pamela Wilson, Willson.
Thank you. Thank you for being here today. Want to ask some preliminary questions here. Where do you work at, please?
Well, I'm actually at this point mostly retired. I still do occasional cases in Arizona, but I live now in Washington State.
And where did you work at while you were here working in the Valley?
I have a private practice shared with one colleague. Her name is Dr. Yablik. She's now doing most of the evaluation work in Phoenix. We had offices at various places in and around Scottsdale over the years.
And what was the name of your company?
The name of the company is Integer, which stands for Integrated Geriatric Behavioral Health Associates.
Okay. And how long did you work through Integer here in the Valley?
Since the mid-1990s.
Thank you. And what line of work are you engaged in, please?
I am a clinical neuropsychologist, and for the last 15 or 20 years have pretty much exclusively done forensic work, probate work, or civil cases.
All right. Do you specialize in a particular field, or does a specialist designation come with working as a neuropsychologist?
I am board certified as a clinical neuropsychologist.
Thank you. And what is exactly neuropsychology?
Neuropsychology is a branch of clinical psychology that looks at brain behavior, interactions and relationships and how things in the environment affect the brain, which then affect behavior, or how changes in the brain affect behavior.
Thank you. What educational experience do you have that prepared you for that line of work?
Well, I have a doctorate in clinical psychology. I got postdoctoral training in geriatrics and neuropsychology, and a little bit of rehabilitation work. And that was a National Institute of Mental Health traineeship. And then I had 2 years of postdoctoral supervision at the University of Arizona in neuropsychology. And at that point, I was able to become board certified.
Thank you. And doctor, did you provide for us a curriculum vitae outlining your experience in education in this case?
Yes, I did.
All right. If you would look at exhibit number 89, please.
Which is?
Exhibit number 89.
I don't have it marked as exhibits.
I'm sorry. It's your curriculum vitae.
Thank you. Got it?
Thank you. Looking that over, the curriculum vitae, can you confirm that this is a true and accurate copy of what you provided to us of your experience and background in education when you were first retained in this matter?
Yes, it is.
Thank you. And just want to look over a couple things in here. I notice at the top, as far as credentials, that it lists you as a diplomate in clinical neuropsychology. I am not familiar with what that is. Can you explain to myself and the jury what a diplomate in clinical neuropsychology is and what the significance is?
Sure. That's what I mean when I say board certified. The American Board of Professional Psychology gives a special credential in a variety of subfields in psychology. Child psychology, for one, various other things. And clinical neuropsychology is one of the specialties, one of the first specialties that they recognize. And to get the certification, you have to submit work samples that are reviewed by other professionals, and if they decide they're acceptable, then you are invited to sit for an all-day written test, and then you go through basically half a day to a day of oral examinations over the field in general, over the specifics of the work samples you've provided, over ethical issues. It's pretty grueling, and if you get through all that, then you can be board certified.
Thank you. Back to your curriculum vitae. Did you put this curriculum vitae together yourself?
Yes.
And so you have knowledge of all its contents and can certify it's true and accurate?
At the time that that I saw the Johanssons, yes, there have been 1 or 2 changes in the last year in terms of memberships.
All right. Move to admit exhibit number 89, Your Honor.
Any objection?
No.
89 is admitted.
Thank you. And Dr. Wilson, before I get away from exhibit 89, I just want to note in here, without going into a great amount of detail, that you have numerous publications listed here. Is that?
I have a few. I wouldn't call them, compared to some people, they're not numerous.
Fair answer, and we'll take that. I also noticed that you have several presentations listed here that take up approximately a page to a page and a half.
That's better.
Any of those that would be relevant to highlight today?
Well, sorry. Most of the work that I've done, both in terms of presentations and in terms of the written works, have had to do either with various types of dementia or cognitive impairment, or with issues of vulnerability or undue influence, exploitation. When I'm working with presentations for physicians.
One moment, there's been an objection. Go ahead with your objection.
None of these publications have been submitted.
Response?
Your Honor, we're just listing the titles of them. They've had the curriculum vitae for years now.
Over your objection, she's allowed to testify. Go ahead.
She's giving content.
when I'm, doing work with medical students, for example, I'm obviously pitching what I'm talking about more in terms of being able to identify dementia. When I was doing work with APS or the probate court, for example, probate court interviewers, then I was teaching more the how to do an interview so that you can get information in a pleasant, unobtrusive, but effective manner. So it all covers some aspect of dealing with cognitive impaired people or making decisions about exploitation or vulnerability.
Thank you, Doctor. Let's talk a little bit about your professional experience, if we might. What jobs or positions did you hold prior to your current position? Within, say the last few, well, I'm assuming at Integer you stayed there for a number of years. Prior,
1995, so that's pretty much what I've done.
Okay, prior to Integer, can you talk about the last two jobs you had prior to Integer?
Well, prior to Integer, I was a neuropsychologist for Maricopa County Long-Term Care, which back in the 90s was considered nationally groundbreaking in terms of both rehabilitation and elder care issues. And I was part of the team that developed an award-winning rehab program and I was doing most of the neuropsychological evaluations throughout the county. Prior to that, I was also doing some private practice during that whole period of time. I should say doing back then. Well, I did some teaching consultation, but I also worked at Meridian Point Rehabilitation Hospital. But really, the majority of my work was first with long-term care and then with Integer.
And then with Integer itself, and you may have addressed this to some extent already, what were your primary functions and duties working at Integer?
My job has always been neuropsychology, clinical neuropsychology. And so that would be doing evaluations of people in clinical situations, for example, helping physicians to diagnose what kind of dementia was going on, or could someone still drive, or could they still live at home? What kind of help or rehabilitation did they need? That increasingly got involved with things like guardianships or conservatorships. And so over time, probably by 2010 or 2012, I was doing far more court-related work than I was plain clinical work.
Okay, thank you. One of the issues in this case, Dr. Wilson, is whether or not one or both of the plaintiffs were a vulnerable adult at a certain time when transactions were taking place. How many times have you administered testing to people to determine if they are a vulnerable adult?
I couldn't possibly begin to tell you. I would guess over the course of my career, it's probably been between 10 and 20 times a year, maybe more. So, 25, 30 years of doing this, that's a lot.
Yes. And same question in regards to vulnerability. One of the questions in this case is whether or not one or both of the plaintiffs were susceptible to undue influence. And so how many times would you have administered testing to determine if a person is subject to being unduly influenced?
That often has gone hand in hand with the question of vulnerability.
Okay.
So it's a little hard to separate them, but approximately the same pretty high number of cases over time. And that has tapered off in the last few years, certainly.
Okay. Thank you. Prior to today, have you ever testified in court as an expert witness?
Yes, many times.
Have you testified as an expert witness on the issue of vulnerability?
Yes.
Have you testified on the issue of susceptibility to undue influence?
Yes.
would you be able to hazard a guess at how many times you've been qualified as an expert witness for either of those two issues, vulnerability and susceptibility to undue influence?
No. A small percentage of the cases I'm involved, I may be retained as an expert, but most of these settle before they go to court. So I would say probably over the years, 75 to 100 times, maybe more. I've been qualified in one or both of those things
All
as
right.
an expert.
And on the issues that you testify or that you were retained for, that asked you to address and opine on these issues that settled, were people looking to you as an expert witness in those matters?
Yes, I was hired as an expert, usually with the expectation that it would end up, going to court. But particularly in the last 10 to 15 years, the probate court in particular has really been pushing hard. Pardon my dog. Has really been pushing hard for mediation and trying to settle cases without going to court. So increasingly, I ended up not having cases go all the way to court. The majority, by far, ended up settling before it got to that point.
Thank you. And for the times that you were qualified as an expert witness, what court were you in and where were you qualified at?
I have been qualified numerous times in Maricopa County, also several times in Yavapai County, a few times in Coconino County, a few times in Pima County, and a few times in Pinal County.
So throughout a large part of Arizona?
Yeah, a couple times in Yuma County.
All right. So to a large degree covering most of the counties in Arizona?
Many of them, yes.
All right, thank you. Have you made determinations of vulnerability under Arizona statutes?
Yes. That's usually the guidelines that I'm under.
And when we talk about vulnerability, are we talking about the statutory definition of vulnerability under ARS Title 46-456?
Yes. I mean, we're talking about someone who's vulnerable due to an impairment, which can be physical, sensory, cognitive, or other.
And besides the issue of vulnerability and susceptibility to undue influence, have you also made determinations on other issues like incapacity and impairment?
Yes. I have done a lot of guardianship work and conservatorship work. And for a long time, I would say that was the bulk of what I was doing. But then the question of vulnerability kept getting mixed in with it, and the state began defining vulnerability a lot more clearly. So that then switched to be the bigger issue.
All right. While testifying as an expert witness in regards to vulnerability, have you applied the definition of exploitation under Title 46 that I mentioned earlier?
Yes.
And does that definition of exploitation include the, quote, illegal or improper use of a vulnerable adult or the vulnerable adult's resources for another's profit or advantage, unquote?
Yes, that's usually what I'm looking at.
All right. Let me talk to you a minute about compensation. We hired you to assist us in this case, did we not?
Correct.
And Mr. and Mrs. Johansson are asking you to render your opinion as to whether one or both were either vulnerable or susceptible to undue influence. Is that what your understanding is?
Yes, through you, they ask me. I mean, usually the clients themselves don't ask me to do that. Their attorney does, and that was what happened in this case.
Thank you. Are you being compensated for being here in court with us today?
Yes, I am.
Tell us, please, how you're being compensated.
Well, for non-court work, I charge $350 an hour, which is a rate I haven't changed in quite a number of years. For court-related work or depositions, I charge $400 an hour because they're not pleasant and there's a whole lot of hidden costs and preparations.
And so far, what has been your fees that have been incurred in this manner up to now, if you know?
It's a little over $10,000 since I started in 2018.
And when you first got involved, what were some of the first things you did as far as the work you were being compensated for? Did you meet with Johannsen's first? Did you review records? Please explain to the jury kind of how that transpired.
The first thing I do is require the attorney to put in writing what it is they want. So there's no surprises later when they say, well, I thought you were going to look at this or that. Once I had that in hand, then my office requested as much as we could get in terms of medical records. And if there were relatively useful banking records or other financial records in a case where exploitation is under consideration, we asked for those. Sometimes we end up trying to track stuff down ourselves because the lawyers sometimes just don't realize how important it is to go back a ways on medical charts, for example. In your case, your office provided me with an assortment of medical records. We came back and asked for more. You were able to get some of them. Some of them we weren't able to get. I spoke to, I think, the CPA and one or two other people involved with the Johanssens, and then I arranged to do an evaluation of them individually in my office. Thank you.
And then discuss, if you would, please, let me retract that question. Did being compensated by Gary and Donna in any way cause you to be biased about the opinion that you will render in this matter?
No. I take pride in the fact that I'm considered fairly contrary and extremely independent. I have made almost as many attorneys unhappy as happy, and I consider that an indication of my objectivity.
And so what you're saying is that the Johanssens haven't bought your opinion to be one way or another in coming into court today.
Correct.
You've arrived at your own independent determination based on your evaluation of the Johanssens and the medical records, their medical records. Is that correct?
Yes.
Thank you.
Correct.
Have you been retained in this matter to provide an expert opinion?
Yes.
And did you prepare a written opinion for this matter?
I did.
And if you would, look at exhibit number 88, which is your written opinion.
Okay.
And it's labeled at the bottom as PM page 1 through PM page 13. Do you see that?
I don't have, I'm just using my own copy. I don't have.
Oh, okay. I'm looking at the report that you supplied our office, which is 13 pages long. Do you have a copy of?
Hang on 1 second. I'll let you object. Go ahead and finish your question. Does she have a copy of?
Do you have a copy of this report in front of you?
Yes, I do.
Thank you. One moment, doctor.
He says exact copy, but it's not a copy that he could give her that was already submitted in here. There's probably a difference, maybe. It's not an exact copy of an exhibit submitted.
So, doctor, can you hold up each page of what you have in front of you for what is Counsel's Exhibit 88? And would you show the camera each page, and you can show Mr. Castavelli, he can compare with what doctor holds up on the screen. So there's page 1.
And hold that up again, doctor, just for a moment so he has a chance to look at it. And back it up.
Yeah, go back a little bit. You
Back
had
it
it
up
good.
from the camera. A little more. Back.
Okay, good.
There you go. That's good. Thank you. That's perfect.
Okay.
And then page 2. And back it up a little bit.
Just a hair. You're good.
There? And page 3 when you're ready. Perfect. Page 4 when you're ready.
It's coming. They stick together.
Perfect again.
That's page.
That was 4.
Okay.
And then page 5, if you would. You're getting really good at this. Back it up just a little bit.
Yeah, you're good. You're good.
At my nose.
All right, that's good, I think. And the next page, please. Very good.
Okay.
All right, next page.
Can't read this.
And raise it just a little bit, bring it up a little higher. There we go. Next page. And bring it down just a little bit, lower it.
That's good.
Okay, next page.
Just making sure.
What page is that?
Page 9.
9?
All right, next page. All right, and float that down just a little bit, lower it.
That's good. I got it.
Okay, we've got it. Next page, please.
What page is that?
Page 10?
No, I don't believe so. Doctor, is that
Page 11.
Page 11, sorry.
Okay.
Yes.
And then the next page, please. And float that down just a little bit.
That's good. I got it.
Okay, and then the last page, what I believe is the last page.
Okay.
Thank you very much.
Thank you, Doctor.
Yep.
So you prepared a written report for us in this matter.
And I'm sorry, you were moving to admit that exhibit, correct?
Not necessarily, Your Honor.
Okay, you're just showing the exhibit. Go
Just
ahead.
showing the exhibit so
All right.
she has it in front of her.
Thank you.
All right. What exactly in this matter were you asked to render an expert opinion on?
I was asked to render an opinion as to whether either or both Gary and Donna Johansson met the criteria for vulnerable adult in period of time in early 2017, or whether they were susceptible to undue influence, and to the extent possible to look back and determine if they were vulnerable or if they were susceptible, at what point that may have begun to be manifest.
Thank you. Your Honor, at this time, I'd like to tender Dr. Wilson as an expert witness in this matter in regard to evaluating persons to determine their status as a vulnerable adult under Arizona's vulnerable adult statute and for determining susceptibility to undue influence.
Any objection by defendants to Dr. Wilson testifying as an expert in these fields?
I didn't get to hear her response when she was asked to retain. She stated I missed it. Said something about early 17.
I think what opposing party is asking Dr. Wilson is, at what point in time were you evaluating the Johanssons? I think you mentioned 2017, but you also mentioned that you went back and looked further, or at what point earlier than 2017? Is that?
I don't understand what you're asking, so I'm glad that he understood. So, Doctor, how far back did you review the records in order to come to your conclusions in this matter?
It's not the record.
I reviewed it. Why don't you clarify what you want me to answer? I evaluated.
Hang on a second. I'm sorry. Defense is talking at the same time. One moment, Doctor. What are you asking?
I'll just ask the question across.
All right. Do you have any objection to the doctor being that I'm going to qualify her as an expert witness on vulnerable adult and susceptibility as an, excuse me,
As a vulnerable adult under Arizona's vulnerable adult statute and for determining.
and for susceptibility of the undue influence.
Yes.
No.
No objections. She's qualified as an expert.
All right, thank you. And Dr. Wilson, I think I know where Mr. Casavelli's going with his question. You mentioned something about looking at whether Gary or Donna were susceptible to undue influence or vulnerable adult in 2017. Did you make that statement? Do you recall?
Yes, that was the period of time you requested me to focus on,
Right.
but also to look back in time retrospectively and see if there were indications of problems that might rise to that level previously. The records I was able to review went back to, I think there were one or two that went back to 2013, but most of them went back no further than 2014. And I want to stress that we were not able to get neurology records that we know dated back to 2012, and it appears that none of the physicians that the Johanssons saw were able to get those records either. So there's a chunk of missing information that would predate even 2014.
All right, thank you, Doctor. In coming to your conclusions that you're going to testify about in a few moments, what procedures did you follow?
The procedures I normally follow, which are, I try to get as much information as I can. I usually make a point of telling attorneys I want everything, whether it's flattering or not to your case. I want all medical records, even seemingly trivial ones, as far back as possible, certainly at least a few years prior to whatever time frame the person has identified as being the problem. So I ask for that. I obtain as much of that material as I can. I go through it carefully, looking for indications either for or against cognitive impairment or vulnerability. I'm as interested in being able to tell an attorney, here are the weaknesses, or here's what you don't got, as I am in being able to say, and here's what you do have. So I think it's absurd to encourage people to spend an enormous amount of money on a legal matter if they really don't have a leg to stand on. So I go through all of that information. I consult with the attorney. I consult with relevant interested parties. That may be, as it was in this case, a certified public accountant. It may be a previous attorney. It may be family members. In some cases, it's the yard guy or pool guy or the hairdresser or barber for the past 20 years. And that's to gain as much objective or independent information as I can. And then I also interview and evaluate through testing the client, as in this case, the client's still alive. I compare any previous cognitive or neuropsychological evaluations very carefully to see if we can find some sort of pattern or trajectory over time. Then I summarize it and write up a report.
Thank you. Did you meet personally with Gary Johansson and or Donna Johansson as part of your process in evaluating them?
Yes, I met with them in August of 2018.
So August of 2018 was getting close to about a year after this lawsuit started. So what did evaluating them in August of 2018 help you to do in terms of the review of their medical records prior to that date?
I need to see a person, if I possibly can, to be able to get my own sense of, let's say, cognitively, where are they at now? What are their strengths? What are their weaknesses? If they're impaired in certain areas, like memory or concentration or language, what are those areas and how bad is the impairment? And then in a case like this, where someone has been evaluated previously, I can look back to the earlier testing and sometimes make direct contrast. You know, that in 2017, they did this well on a test, and now I've seen them, they did this well. In this case, there was also testing done in 2015, although I wasn't able to get all the raw test data, I was able to get many of the scores. So I could see if there's a trajectory, if there's a pattern that fits a particular diagnosis. That also lets me determine whether someone met criteria for susceptibility or potentially vulnerability at an earlier date. But I have to have an anchor point whenever possible. And so that's why I evaluate people myself.
Thank you. What exactly did that meeting with the Johansons cover?
Well, I do a clinical interview with each of them independently, and then did some cognitive testing with each of them independently.
And can you explain to the...
But I didn't speak to them together at any point.
Okay, thank you. Can you explain to the jury what a clinical interview is or what it involves?
Clinical interview is sort of like taking a history, you know, tell me what's going on now, where did you go to school, where did you grow up, tell me about your life, what problems are you having now. And during that process, I'm not only gathering information, but I'm looking at how well the person can organize their own story, how well and how coherently can they communicate. Do they have trouble understanding the questions I'm asking? Do they have realistic sense of things? Are they showing some degree of insight into how they've been and how they are now? Or do they think everything's hunky-dory when, you know, blatantly isn't? So it's a combination of fact gathering and obtaining clinical observation in a non-threatening situation.
Thank you. You also mentioned something about testing that you would have performed on Mr. and Mrs. Johanson. What kind of testing is typically administered by you in those kinds of sessions?
Well, neuropsychological tests are tests of memory, language, visual and spatial thinking, conceptualization, analysis. It covers a broad range of abilities, and we sort of divide them out so I can look at a particular kind of memory, particular kind of verbal memory as opposed to visual memory for things the person has seen. I can look at strengths and weaknesses that way, and certain kinds of cognitive problems, certain kinds of dementias will show a pattern that's pretty consistent across people, and that changes in a predictable way over time. The tests that I use are all standardized. They are recognized by neuropsychological community as being scientifically solid, statistically adequate, at least, if not better. And I can determine, compared to people in, say, the same age, same education bracket, how did Mr. Johanson do? Was he in the top 5%, the bottom 2%? How did he compare with his peers? And also, how did he compare with himself over time?
Thank you, Doctor. I don't know if you mentioned it here or if I saw it in the report, but as part of your testing, I know one of the things that you've mentioned is that you tested verbal memory. What do you mean verbal memory?
Well, just to make it complicated, because I'm a neuropsychologist, there's a whole bunch of verbal memories. There's the main two types that we test, or the main three types that we test. There's verbal memory for material that's not really well organized, and that would be like a really long shopping list, you know, where somebody's going to be going to grocery store, Home Depot, what have you. They have to be able to retain that, and that means they have to impose some organization and structure on it to be able to learn it and keep track of it, and be able to pull it out later when they're asked about it. There's also organized memory, and that's like short stories or jokes where there's a built-in organization and context. That typically is much easier to remember because pieces are linked together logically. And people may do very well in one and very badly in the other, and that tells us something both about memory, but also about whether they can organize and manage their memory, or whether they have to have that done first for them. Then there's verbal working memory, which is the ability to keep something in your head for a few minutes while you're making coffee and then remember that you need to do it, and many other types of verbal memory.
And then there's also a mention in your report about visual memory. Can you give us some background on what that might involve, please?
Well, visual memory is certainly things that you've seen, and that ranges from street signs to a place you've been before or faces that you've seen, all of which are processed in slightly different areas of the brain. So if we do find a specific loss of facial recognition, we know where that is in the brain, and that can help us identify what's going on that's a problem. There's just trying to remember designs that you haven't seen before, and that can be whether you see it once and are then unexpectedly asked to remember it, which is a difficult kind of visual memory, or whether you are given several opportunities to copy it and told, you're going to need to remember these, I'm going to ask you about them. And again, that's a degree of organization. Can the person impose their own organization as they're copying the design so that they can remember it? Or do you need to tell them, practice these, you're going to have to remember them? And so, again, there's several different subtypes of visual memory. It is not that closely related to verbal memory, so you can have strengths in verbal memory and be terrible in visual memory, or vice versa. And again, that tells us parts of the brain that might be affected.
All right, in regards to the tests that you administered to Mr. Johansson, can you talk to the jury and the court about what his test results were and how you interpreted them?
Well, his test results for me were, if you don't mind, I'm going to pull up my score sheet here. I can tell you accurately. I gave a basic mental status, and he scored at the first percentile for his age and education. And what that means, first percentile means 99% of his peer group would have done as well or better. He's in the bottom 1%. I gave tests of visual memory and tests of verbal memory, and he was extremely impaired on disorganized learning and verbal memory. He was not able to impose any organization to be able to remember a list. He could recognize, and if you gave him cues, he could recognize some of the elements, but he was not able to recall them, and he really was not able to learn them. Same kinds of things with limited visual memory testing. His visual memory had been shown to be profoundly impaired by 2017, and it certainly didn't improve. And his verbal memory deteriorated even further than it had at the previous testing. I tested abstraction, his ability to think, how are things alike or different, his ability to do some fairly simple problem solving, his ability to sustain attention to one part of a task while being able to ignore something else, or being able to go back and forth, for example, 1A, 2B, 3C. That was almost impossible for him to do. So I was able to determine that he had extremely severe cognitive impairments in most areas, and nothing was really in a normal range given his age and education.
And that is all for testing that you did in August of 2018, correct?
Correct.
And then you also obtained Mr. Johansson's prior medical records so you could look back on those as well. What did you find in his medical records that is of significance to your conclusions that you're going to be offering here today?
Well, I found a number of things. Let me first mention he did have neuropsychological testing about a year, maybe not quite a year before I saw him. And I was able to get the actual test materials. That was from Dr. Powell, Dr. Jessica Powell. So I was able to make a direct contrast. And I noted that she didn't always use the appropriate age corrections. So he actually did more poorly on some of her testing than she stated in her conclusions. But he did really badly for her. And I mean, she said as much, but he did worse than she thought. There also was testing done in November of 2015 by Dr. Etling, and I was not able to get his raw data. He is notoriously resistant to releasing raw data, even though he's supposed to. So I had to work off his scores that he listed in his report to the best of my ability. Even there, in 2015, there were very significant areas of impairment. And I was able to document a clear, consistent decline that was entirely in keeping with the diagnosis of what we call Lewy body dementia, or the Lewy body type.
All right. And I note from your report that after you met with Gary and Donna Johansson personally to get their clinical interview and test them, that you also may have had further contact with them after that meeting?
I had contact by phone with Donna. She was a difficult person to interview. She was sort of all over the place. I mean, Gary was incoherent, but she was very tangential and hard to sort of pin down. So between things that were in the medical records where she had said she would take over financial management, and then a year later would say that she would take over financial management, and what she told me, which was that she'd only done it fairly recently, you know, I was left scratching my head thinking, well, how long ago did she actually step in? And I asked her if she had any check registers or things like that that would be able to show me the point at which she'd really started to take a more active role. And I stress, do not send me the check registers. You know, have your attorney make copies of them, or you make copies of them. Do not send the check registers. And she sent the check registers. And they weren't really for the right period of time, so they weren't that helpful. It appeared that she had popped in for a few weeks here and there since about 2015, but at no point did it seem clear to me that she had actually completely taken over the checks, at least in the time period that she sent me.
Thank you. You mentioned in reference to Dr. Etling and possibly Dr. O'Coin that you were able to review raw data from either one or both of them or from Ms. Powell. Can you tell Dr. Powell, can you please explain to the jury and the court why it's significant for you to be able to get raw data and how that helps out your opinion here today?
Sure. Let me just clarify. It was the neuropsychologists were Dr. Etling and Dr. Powell, and that's the raw data that I saw. We all can make mistakes in scoring, and frankly, I mean, I'm going to sound like a real old fogey, but younger generation of neuropsychologists have had a fairly sloppy training in terms of applying proper corrections for age and education and even gender. And so it's very important to be able to see what did the person say in testing a year or 2 or 3 years ago, and was it scored properly, and were the age corrections and education corrections applied? And I know from past cases that Dr. Etling was inconsistent at doing that. And I was a little surprised to find that Dr. Powell was also inconsistent in applying those kinds of necessary corrections. Now, someone who's had a master's degree is not going to perform the same way on a lot of tests as someone who has a 9th grade education or even a high school education. And so you really have to take those things into account with some of the tests. So looking at that and also being able to see things, Dr. Powell mentioned in her summary sheets that there were some intrusion errors on one of the tests. And what that means is things that didn't belong on the test got stuck in. But when I looked at the actual raw data, there were more mistakes and more repetitions than there were accurate answers. And that's a severe problem and should have been mentioned in her report. So looking at raw data tells you a lot that you would otherwise miss.
And you were able to review at least some of that data and incorporate that into your opinion here today?
Yes.
Thank you. In reviewing your report, I noticed that you tied some significance to Gary Johansson's medical history related to diabetes. Could you please comment on why that would be significant in your eyes in terms of the opinion you render here today?
Sure. There's actually two pieces to that. The first part is diabetes itself, particularly poorly controlled diabetes, which is what he had. He had what's called brittle diabetes, and that means he could go from almost fatal hypoglycemia, low blood sugar, to dangerously high blood sugar in a relatively short period of time, a day or two sometimes. And then it would go back down, and so it was very hard to manage. It required, a fair amount of organization to try to control it. People who have that kind of diabetes are known to have much higher risk of cognitive problems, changes in the small vessels of the brain, or tiny strokes, for example, that may not even show up on scanning. When a person's blood sugar is very high or very low, they are not able to think clearly. They are not able to make good decisions, those sorts of things. So just the fact that he'd had brittle diabetes since the 1990s would, I think, make any neuropsychologist concerned that something might have been affecting his cognition during that period of time. The other piece that emerged in looking at the management of his diabetes is that as early as January of 2014, his endocrinology team was saying he can't manage his diabetes. He's too forgetful. His judgment is impaired. He doesn't have insight into how risky what he's doing is. They were talking about him needing to be assisted or someone else supervising his diabetes or even assisted living in 2014. And that continued throughout. So in addition to having brittle diabetes, he was clearly not able to even take a reasonable stab at managing it. And from the records and from what Donna told me, he would not consistently let her supervise or even assist him. When he wanted to do it his way, by God, he was going to do it his way.
All right. You also mentioned in your report, I'm sorry. Did I hear something?
No.
Okay. You also mentioned in your report a history of serious depressions with suicidal feelings. Why is this significant to your analysis, in your opinion?
Again, there's two pieces here. One is whatever the cause of severe depression, and feeling suicidal is sort of by definition going to be a very severe clinical depression. That makes memory unreliable. It makes people inattentive. It makes them more passive and more dependent. Someone who's very depressed doesn't feel like they have the energy or sort of the get up and go to do even simple things. And so if someone else offers to do it or takes on the burden, usually they're more than willing to let that happen. They may complain about it, but willing to let that happen. But in addition, diffuse Lewy body dementia comes on in a couple different ways. Excuse me. It comes on in a couple different ways, and one of the ways that it comes on is in the form of severe psychiatric symptoms such as severe depression 10 or 20 years before it's actually diagnosed as Lewy body dementia. So the onset of a relatively late life, in his case probably in his mid-50s or 60s, severe relentless depression indicates that that is probably dementia of the Lewy bodies type in its earliest form.
Thank you. In regards to
Counsel, that brings us to our afternoon break, so this might be a good time before you ask your next question. Doctor, my apologies. It is time for our 15-minute afternoon break. We will reconvene in 15 minutes. Thank you.
Excellent. Thank you.
Thank you, Dr. Wilson.
All rise.
Thank you. Please be seated. Let the record reflect the jurors are excused. We are on our 15-minute afternoon break. Doctor is appearing on Teams. She has at this time been muted, correct? All right, so that recording is paused. Anything additional for the record at this time?
No, Your Honor.
All right, see you back in 15 minutes. Enjoy your break.
Thank you.
Thank you.
I know. I'm sorry. Okay. Can I do anything?
Okay. That was hard.
Yeah.
It wasn't Gary she's describing. We all know that.
No way.
There's a deposition video that absolutely proves that's not Gary she's describing.
Yeah, no.
Go play the video.
She didn't describe me very well either.
I know it's hard. It's hard to hear anybody talk about Gary like that.
Don't let him get to you. I know. It is hard. Walking a little bit.
Yep. Okay.
Okay. This is tough to hear. I know. It is hard. Hard to hear all the stuff that he went through and stuff. Yes. How difficult it was.
Like this, he